Hi, my name is Nasrin Binti Zuperi and my metric number is 272244. So our group consists of 5 members, which each members will highlight their own main focus of discussion in order to answer the question given in the assignment. So our group has decided to choose the question on whether defense of fair dealing creates a new copyright in a derivative work. So first of all, I will be presenting on the introduction part. So for the introduction part, I will tell you on the purpose of the assignment. So the purpose of the assignment is to acquire the answer on whether defense of fair dealing could make derivative works eligible for new copyright protection. So through this assignment, thorough discussion will be explained and presented in order to show you the answer and our proof on our answer to the question given. So I will explain briefly on what is exactly fair dealing, the theory behind the defense of fair dealing, and also how the court determine on whether the work is fair work. So first and foremost, what is exactly fair dealing? So fair dealing is actually an exception for copyright infringement provided by the copyright law. So what is the reasons behind the defense of fair dealing? So the theory behind the defense of fair dealing is that it functions to impose proper balance between protection of right of the author and also public interest. So copyright law actually plays its role to promote the works of arts and at the same time ensuring a just rewards for the creators of the masterpieces. So in order to raise the defense of fair dealing how do courts determine whether the work is fair? So basically, it depends on the circumstances and also guidelines provided in the copyright law. So one of the consideration that the court will take into is that the purposes of the derivative works, so that the court will determine on whether the work can be constituted as fair work. So further explanation on fair dealing and derivative works and also the provisions provided in the copyright law will be explained by my friends, followed by cases and also analysis.
Assalamualaikum and good morning. My name is Suhada Binti Muhammad Saidi and my metric number is 272753. And today I'll be presenting on the requirement for copyright protection of derivative work. So in order to claim copyright protection for derivative work, there are two basic requirements that need to be fulfilled by the adapter of the derivative work. Firstly, the content of the derivative work must be based upon the expression of the original work. If it only reuse the general concept of the word instead of the expression of the original work, then it will not be a derivative work under the copyright law. And the second requirement is that the new adapted derivative work require a sufficient level of efforts based on the expression of the original work. So even though the work used contains the original expression of the work, but is lacking in terms of creativity, the work cannot be called as derivative. So as derivative were adapted from the original work, the condition for the option of originality is stricter than in original works. So in order to enjoy copyright protection, the adapted work needs to meet all the requirements that have been laid down. So after fulfilling all these two requirements, another thing to be needs to be taken seriously by the adapter of the work is in obtaining license. So in obtaining license, only the original owner of the work can authorize someone else to produce an adaptation of that work. So the right obtained was only to perform the agreed derivative work, while the original right of the work and all its components will remain to the owner. Once permission has been granted, the right to utilize the original work in the new derivative work will be permanent and cannot be taken back by the original owner. And also, once the original work have been adapted and turned into a derivative work, the copyright protection for the original work will still remain the same and not be extended. So, the application of the general rule in obtaining license and new copyright for derivative work is explained in the case of scope photography against Learning Curve International Incorporation and Heat Entertainment. In this case, the original copyright for the train character, Thomas and Friend, was owned by Heat Entertainment and license was given to Learning Curve International to produce toy figure based on the character. Scott was then hired by Learning Curve to take photographs of the toys for marketing purpose, which means there are more derivative work created. The picture was continued being used by Learning Curve even after 4 years the company stopped giving Scott work. Scott then put his work for copyright protection and filed a claim suit to Learning Curve and Heat Entertainment for copyright infringement. And the court held that once permission was granted to Scott in creating the derivative work, the owner of the copyright for the derivative work will be wasted in Scott. Thus, the unlawful use of the derivative work by the company will constitute a copyright infringement even though they own the right to copyright for the original work. That's all from me. Thank you.
Good day, I'm Ong Lee Xuan with metric numbers 272938. Now, I would like to present to you the elements of fair dealing defense. According to Sections 13, Subsection 2, Part A of Copyright Act 1987, there is no copyright infringements if the acts restricted by copyright are done through fair dealing. The exceptions of fair dealing is often related to reproductions to copyright work for non-commercial purposes such as education, research, private use, retrieval and library use, journalism, criticism, and parody. There is no statutory definitions of the terms of fair dealing stated in the Act. However, in the case of Hubbard versus Vosper, the court held that it is impossible to have any definitions of the terms of fair dealing as its existence or otherwise in the context of each case is a question of degree to be determined by the court. There are some guidelines provided under Section 13, Subsection 2A of Copyright Act 1987. And it lists down a number of factors to be considered by the court when determining whether a dealing constitutes a fair dealing. The factors include the first one, the purpose and characters of the dealing, whether such dealing is of a commercial nature or it is for non-profit educational purpose, and the second one, the nature of copyright work. The third factor, the amount of substantiality of the portions used in relation to the copyright work as a whole. And the final factor, the effect of the dealing upon the potential market and its values of copyright work. Now, I will pass it to my team members, Jun to further explain about the purpose and characters of the dealing. Thank you.
My name is Lim Jun Ni, metric number 272913. I am going to present one of the factors to determine whether a dealing constitutes a fair dealing, which is the purpose of the dealing. These factors had been stated under Section 13, Subsection 2A, Part A of Copyright Act 1987, and it was applied in the case of Fraser Woodward Limited. From Section 13, Subsection 2, Part A, we can note that the word including is used. This broadens the scope of the fair dealing purpose and not limited to the purpose name only. By doing so, It gives more flexibility to the court in deciding whether the defense of fair dealing may be invoked. One of the main purposes is research and private study. Research can be defined as diligent and systematic inquiry or investigation into a subject to discover the fact and principle. In the case of Canada Law Book Incorporation versus Law Society of Upper Canada, the court held that the services, which was an integral part of the legal research process, is also allow fair dealing defense to be invoked. Recently, only non-profit research can be raised in this defense. However, the word non-profit may be troublesome because it brings a lot of unreasonable restriction. Therefore, in Media Crop News Limited proprietary limited case, it was held that in determining whether a dealing is fair, the totality of the operation should be considered, instead of setting apart the activities into different divisions and concluding that division is for non-profit research purposes. Moreover, under the scope of the research, this defense can only be raised by the researcher himself. However, when a person is on the on the acts upon the request, for instance, the librarian, the court will examine whether how the work were dealt with. If multiple copies were made and circulated to more than one person, this will rupture the defense of fair dealing. As for study, it only covers private study. Similar to research, this fair dealing defense can only be invoked by the person undertaking the study. This was ruled in University of London Press Limited versus University Tutorial Press Limited, where the court held that a person who merely conducts activities to facilitate that private study is not entitled to claim for the defense. Besides, private study which was conducted for commercial purposes also was not protected under the defense, and this was stated under the case of Creative Technology Limited versus S-Stage System Proprietary Limited. The another named purpose is criticism or review. It refers to taking part or extract from copyright work and adding some personal opinion and ideas that can be found in the work and its social or moral implication. The case that can be referred to is the Pro-Sibian Median AG versus Carlton UK Television Limited. While in Ashdown versus Telegraph Group Limited, the court held that the criticism on matters other than the copyrighted work is considered as irrelevant to the defense of fair dealing. Although there is no requirement that the criticism or review must be judicially expressed, but the part constituting the criticism or review must not be a mere summary or exposition of work without any review or critical content. Next purpose is reporting of news or current events. Reporting of news including reporting of recent events and can be extended to information related to the past events which were not previously known. Anyhow, it is not restricted to the reporting of recent events. It will be qualified for fair dealing provided that there is a genuine news component. The rationale for the fair dealing exception in respect of reporting news and current events is to protect the role of the media in informing the public about the matters of current concerns to the public. This can be seen in Ashdown versus Sunday Telegraph. If this exception does not exist, the media need to acquire permission from each of the copyright owners, and this obviously slows down the process of delivering the latest news to the public. Moreover, in England and Wales Cricket Board Limited and Sky UK Limited case, The court held that it is not necessary to include commentary in the report, as long as it is for the purpose of reporting news or current events. The defense of fair dealing can be invoked. All in all, as long as the purpose test is satisfied, the derivative work may be exempted from the infringement of copyright under the defense of fair dealing. Thank you.
The second factor of establishing the defense of fair dealing, as mentioned under Sections 13, subsection 2a, Part B of copyright work, is the nature of the copyright work. The element to consider in the second factor includes whether the original work which is copied by others is unpublished and whether it is a creative expression for public disseminations. The disseminations of the facts and information to the public will allow the author of derivative work to have more leeway to copy from factual works. Copying from a published work have a stronger stand for defense of fair dealing compared to copying from an unpublished work. This is because unpublished work is considered more deserving of copyright protection, and the scope of fair dealing for unpublished work is narrower because the author of the work is entitled to control the first publications or release of his work. In both of the US cases, Wright versus Warner Books and Salinger versus Random House, since the copyrighted letters are unpublished, the second factor, which is the nature of copyright work, weighs heavily in favor of the owners of the letter. Next, in the case of Ballard versus Pressdrum Limited and others, the judge mentioned that the relevant factors of fair dealing includes whether the work was unpublished and the extent to which the work had been circulated, and the motive and intentions of the illegal infringer. The judge stated that the law, by bestowing a right of copyright on an unpublished work, bestows a right to prevent its being published at all. And even though an unpublished work is not automatically excluded from the defense of fair dealing, it is yet a much more substantial breach of copyright than publications of a published work. This is similar with the concept that we discussed in the previous slide, whereby the defense of fair dealing for unpublished work is still allowed, but the scope of it will narrower compared to a published work. To conclude, the person who produces a derivative work should ensure that the copyrighted work that he referred to is a published work and not a confidential document or an unpublished work. It is in order for him to establish the defense of fair dealing. Now, let my team member Xian Lit to further explain to you the third factor. Thank you.
Good day. My name is Koay Xian Lit with my matching number 273677. Now, I'm going to continue the sharing regarding the third guiding factor to determine the fair dealing, which is stated under Section 13, subsections 2A, Part C of the Copyright Act, which is the amount and substantiality of the portion used in relation to the copyright work as a whole. This factor is well agreed by the judges in the case of Frizzle Woodwork Limited against British Broadcasting Corporation, Brighter Pictures Limited. The judge submitted that in the case of fair dealing, the amount of work used and also the substantiality of the part reproduced can be the element for the court to take into the consideration of whether what has been done is fair dealing or not. So, for derivative work, the less it takes from the original work, the more likely the copying will be excused as fair dealing. For example, if a defendant published a long and important extract which derived from plaintiff work and added only a short and brief comment upon it, the court will arrive at the conclusion that that was not a fair dealing. This view of law can also be seen in the case of Herbert against Wasberg, where the court held that it would be unfair for the person to do his work by taking long extract and attach short comment, but it would be fair if they attach short extract and give a long comment. But in some real cases, the court may evaluate this factor on a case-to-case basis, because there's also a case where the use of an entire work can be found as fair dealing under certain circumstances. Okay, move on. Under this factor, the court looked at both the quantity and also the quality of the original work that was used by the derivative work. So, not only amount, the court may also look at the substantiality of the portion used. If the selected portion was said to be the substantial part, or we say as the important part of the work, then it can be determined as not fair. This is because it may affect the current market and also the value of the original work due to its substitutions by the derivative work. The more of the original work taken by the derivative work in amount and also substantiality, the greater the negative impact on the market for the original work. Okay, so to some extent, this factor has worked in tandem with the subsequent factor because the amount taken and the significance of the portions help to determine the degree to which the work may serve as the market substitute for the original. We can see in the case of Twin Peaks against Publications International Limited, a company has published a book entitled Welcome to Twin Peaks, which contains a direct quotations and also paraphrase from the television show Twin Peaks. So it includes all the details, description of the plot, characters, and also setting. And then in this case, the court held that the amount of the material taken by the derivative work was substantial, and the publication has adversely affected the potential market of the program. Therefore, it's said to be not fair. So lastly, what we should remember is that this factor can be said as subjective in nature, where it depends upon the circumstances of the cases, as there are no predetermined numerical or percentage limit for it to constitute as fair dealing. The fourth and the last factor is the effect of dealing. By the wording of Section 13, subsections 2A, Part D of the Copyright Act, this has been included as one of the guiding factors in determining the defense of fair dealing. If the use of derivative work has acted as the substitute of the original work and has severally determined the market of the original work, as well as affect the commercial interest of the copyright holder, it's not likely to be considered as fair dealing. Fair dealing is said to be properly applied when the copying does not materially impair the marketability of the work which is copied. So if the copyright owner wishes to negate such defense, they only need to show that if the derivative work becomes widespread, it would adversely affect the potential market of the original work. On the reading of the Malaysian case of Media Corporation News Private Limited and 3 others against Media Bench, Senia Berhad and 4 others, the defendant has recorded the entire of the plaintiff television's news program. The defendant's such activity would found to be detrimental to plaintiff potential market because the public would purchase the copies of the plaintiff broadcast from defendant rather than from the plaintiff themselves. Therefore, it's undeniable that the plaintiff has suffered loss due to the substitution by the derivative work. As a result, it has been held that the defendant's action does not amount to fair dealing. Further, look at the case of Harper and Row against Nation Enters. The Nation magazine published an excerpt which derived from the ex-president's unpublished memo. Such publication was made several weeks before the date of the ex-president's book was said to be serialized in another magazine. And then the court submitted that the Nation's copying has seriously damaged the marketability of the ex-president's serialization right. Hence, the defense does not succeed. So to sum up, in order for derivative work to obtain a copyright in the defense of fair dealing, they should always make sure that the current marketability of the original work, as well as the revenue generated from the original work, will not be affected due to its substitution or displacement. Thank you.
So, moving on to the last part of our presentation, which is the conclusion part. So we can conclude that derivative works are indeed entitled for new copyright protection by way of defense of fair dealing, and if the requirements are fulfilled, then the defense of fair dealing can be raised. However, the downside is that this defense is not absolute for all copyright infringement occurred in creating derivative works. So the second one is it could be proof how guidelines and rules provided in section 13 subsection 2a and also section 13 subsection 2 and subsection a of the Copyright Act is actually important to assist the court by listing a number of factors into consideration for the court to determine whether a work can be constituted as fair dealing. So the third one, we could conclude that the guidelines provided is to ensure the derivative work would not affect the original work in terms of marketability and also revenue. And lastly, in short, it could be said that all requirements need to be fulfilled and adhered to in order for the derivative work to be eligible for new copyright protection. So that's all from us. Thank you.